All right, folks, we're diving into a heated Georgia courtroom where defense and prosecution clash over one of the most controversial rules in sexual assault trials, Rule 412. Buckle up, because this isn't just legal jargon. It's strategy, tension, and contempt all rolled into one.
Holden, you have an objection?
I do, Your Honor. Mr. Yalamanchili and I had talked in anticipation of us getting to this point over the weekend. That since I had made opening statement,
You pull that microphone towards you. Thank you.
that I would object since I had made the opening statement, but since Mr. Yalamanchili had made the 412 arguments in the past that he would handle.
All right, thank you. Go ahead, sir.
Your Honor, as the court's aware, as the state's aware, if Mr. Cruz wasn't aware before we started all the pretrial motions in this case, he ought to be aware now. Making reference, whether it's a statement made by some other witness, whether it's elicited in direct examination, cross-examination, or any other method.
Quick sidebar. Rule 412, often called a rape shield law, blocks most evidence about a victim's sexual history. The idea? Protect privacy and prevent unfair bias. But here, the defense might be towing that very line, and the prosecution is not having it.
To a relationship between Ms. Baker and anyone else that was not noticed by the defense as a 412 act is prohibited by 24-4-412. I'm not sure how much clearer the statutory language could be, not sure how much clearer the court could possibly have been in its instructions, but whether it's Mr. Cruz making reference to a statement that some witness made during an interview with law enforcement, or whether it's Mr. Cruz eliciting the testimony on direct examination or cross-examination, it is all prohibited by the rule, which Mr. Cruz has violated now for the second time in his opening statement. It does not matter. It does not matter one bit whether or not Chris Melton said that in an interview to law enforcement for the analysis of whether or not it is admissible and the methods that must be adhered to if the defense intends to admit it in any way, shape, or form, Judge. And so this is the second time before we've called the first witness to the witness stand.
Oof, that's a direct hit. The prosecution's basically saying Cruz is ignoring court orders on purpose. What do you think? Is this bold courtroom strategy or a serious misstep that could backfire big time?
That Mr. Cruz has violated 412 in what seems at this point to be an intentional pattern to try to work his way around the laws and rules of the state of Georgia as it relates to admissible evidence in cases involving allegations of rape and aggravated sodomy, Your Honor. So again, at this point, I don't know what the remedy is that the court wants to enact, but obviously telling Mr. Cruz not to do it isn't effective because he's not listening and he's not following the court's orders.
Thank you. Cruz.
And there it is. Cruz fires back. He insists this isn't about the victim's sexual history at all, but about showing another man's guilt. That's a risky interpretation of Rule 412, because it all hinges on intent versus implication.
Any response?
Absolutely. I'm actually blown away and in shock that the state is taking this statement to be a 412 argument. Our theory of this case is that Chris Melton committed this crime. Chris Melton's statement, when he's confronted with DNA that he already knew was present, that she was with someone else, it has nothing to do with us trying to get around 412. That statement is for the sole purpose of showing his consciousness of guilt. He knew this information in 2001. He's told the exact same information in 2024. And his response isn't, oh, my girlfriend, I can't believe this happened, you guys better find her. His response is just simply to say, oh, well, must believe her. It means she was with somebody else. There is no evidence that I intend to present that Chris Melton knows about Ms. Baker's sexual history. There's nothing I can intimate that Ms. Baker knows, that Mr. Melton knows about Ms. Baker's sexual history.
Now, here comes a judge, and if you follow this trial, you already know what's coming. She's warned Cruz before. Let's see if patience or punishment wins out this time.
The purpose of that statement has nothing character under 24.412, sexual character. The purpose of that statement is to show Chris Melton's response. When he's presented with some evidence, he gives a response that's inconsistent with the person that is innocent. So this isn't a 412. I understand the state may not like what I present, but that does not mean I have to preview every single statement I have to them so they can prepare their case. This is open statement, Sean. I respect the court. I do anything for this court. I've told the court that multiple times. This is not a 412 argument. This is Chris Melton, who knows nothing about his neighbor's sexual history, being confronted with a piece of evidence and making a statement that shows consciousness of guilt in our court. This has nothing to do with sex.
All right, thank you. As this court has stated multiple times, this is the second time today, multiple times during hearings, that there is a process that must be adhered to in order to get the appropriate permission from the court to introduce statements, evidence that another party objects to. In this particular case, it is a 412 motion. We have talked about this over and over again. What I have said over and over again is that the defense has failed to file a motion under 412. The state did. The defense has failed to file a motion, and I've said many times that if the defense files a 412 motion, even though it's not timely, the court will consider it. There has been no motion filed. Mr. Cruz, you've been made aware many times that you are not to bring in this kind of statement.
And just like that, contempt of court, $1,000 fine, and a very public reprimand. The message? Even seasoned attorneys can't sidestep courtroom rules. What do you think? Was this fair enforcement or overreach?
I mean, I realize I have said several times today that opening and closing arguments of the attorneys and arguments are not evidence, and I'm going to say it again when the jury comes out. But you've been told many times that in order to, I'm talking now, Mr. Cruz, thank you. You have been told many times that in order to present statements like that, ask for the admissibility of evidence like that, you have to file the proper motion. And the court may consider it even though it's not timely. As I just stated 10 minutes ago, I do find your statements to the jury to be avenues to circumvent 412. And it is not appropriate. I'm finding you in contempt of court. You have had the opportunity to explain yourself, and I'm fining you $1,000. And you are to present that $1,000 tomorrow morning by 9 a.m. Put it into the registry of the court. And that is my sanction for continuing to not abide by this court's orders. I don't know how many times we're going to have this, but it really can't happen again. $1,000 tomorrow morning by 9 o'clock. You may bring the jury out. Thank you.